joke? That's
I did not. You are live, by the way, just so you know. We're early by
live?
like
All right.
we're early by 10 seconds. JR,
10 seconds.
hello, wave.
Yo, what's up? We haven't talked
Nice
in a while, right?
I know. We had like I was gone and you were gone, and sometimes we're both gone. That's what people say. So not legal advice and JR, here we are on Monday. This is like a special Monday night episode of Sunday night live stream, right?
Yeah.
It's like the special edition of Thursday Night Football and all that nonsense. So, you know, every week people ask me questions, and this week, I don't know where it came from, but the rumor has it, and I'm going to let you kind of clarify it if you can. The rumor has it that Taylor Swift has dumped Travis Kelce and has picked up JR. Is that true?
I can neither confirm or deny that. No.
Yeah, some people
that's not true. Taylor Swift is not my type.
You know, if you were under an NDA, you couldn't admit it anyway, right?
Yeah. Well, given the amount of money that young woman makes, I think anybody that's with her should be under an NDA if they're not.
And, you know, since this is a legal kind of, we're talking legal here. So, but if you were under an NDA and I asked you that, you couldn't tell me if in fact you were dating.
I would either be able to confirm. The appropriate language is I can neither confirm nor deny that I'm under an NDA with Taylor Swift.
Or you could just exactly. So my question is unanswered. So I will just speculate until we see next week. We really don't know. We don't know.
I can assure you that Taylor Swift is not in my basement.
That I know. I don't even think you're in your basement, by the way. I don't even know where you are.
I am.
Okay.
No, all right. I'm in your basement.
All right. So we put that to bed, at least for this week. We'll see next week. It'll be public. Listen, you can't hide this kind of stuff. So if it actually happens, JR, it's public. And you're going to be embarrassed next week on the live stream, but so be it. I got to move on. So did you hear about the man that lost his left side?
No. What happened to the man that lost his left side?
He's all right now.
Hold on. I got one. Hold on.
Oh, good. Good.
Hold on. Where? Oh, there it is. All right. Hold on. I was wondering why the Frisbee kept getting bigger and bigger, but then it hit me.
Yes. Just to be clear, I've used that on my videos, just to let you know.
Oh, is that where it came from?
No, I'm not going to accuse the person of that because we may have had a common source, but you know, what great minds think alike. That's what it turns out to be. The girl thought she knew me from the vegetarian club, but I had never met herbivore.
All right, that wasn't too bad. So public. Go ahead.
Last, I put up a high voltage fence around my house. My neighbor is dead against it.
All right, folks. There's the 3 jokes for the night. Now we can move on to more serious stuff.
Yeah.
So
we're going to start off with. I'd like to start off with your FOIA appeal. I think it's a timely question. So tell us a little bit about that, and explain again what a FOIA is and that kind of stuff.
Okay, so FOIA is the Freedom of Information Act statute that allows you to make requests to our government. You know, I don't know exactly how broad it is, but it's traditionally used to get records and materials from the executive branch. You can't FOIA the judicial branch. I think they're specifically excluded, as well as Congress. So it's really the executive branch, and that would be the White House and all the agencies that fall under the purview of the executive branch of our government. So, as many of you know, we sent FOIA requests out a dime a dozen. You know, basically, I mean, I'd be willing to bet 2 or 3 go out a day. I did mine back in, I want to say April, and I requested, as you can imagine, blue sheet data, share count data, pretty much anything that had the final share count on the 9th of December. Any information that had the final share count on it. I tweaked it because I was really I really was trying to get email communications that had the final share count. I figured if I did get stuff back, it would be redacted, but I initially knew that it was going to be denied, and you and I had talked about that. It was just a formality. So got it back, denied, and I got it back in July. I started working on the appeal. Probably while I was at the beach. I really started working on it when I was down at Outer Banks. Came home, took a little time off, went back to it the beginning or the end of September. My appeal was actually due October 9th. And so I made 4 different arguments under the 4 exemptions that they use. They use 7A, 7C, exemption 6, and then exemption 8. So 7A was the big one, that they're holding it back for purposes of, a pending investigation that they don't admit or deny its existence on. And so I researched some case law, found some stuff that I thought was helpful, and made the argument that, look, this is a bullshit investigation, and even if it is an investigation, I'm not part of that investigation, nor are your investigations or enforcement proceedings public. So how can any harm come from providing a simple number? I said that they misread the statute because there's a provision in the statute that allows you to segregate information out.
Is there a way you could make this story longer?
You asked me to go through it. That's what you said.
Just joking, buddy.
So short answer is it got denied.
And there you have it. What's your remedy now?
So, well, my remedy is to go into federal court. So draft a complaint and file a lawsuit against them. Now, the unique thing about...
If I recall, you kind of looked at that at one point in time, right?
Yeah. So the unique thing about FOIA, normally when an individual files a lawsuit, the burden of proof is on that individual. When you file a civil claim like this would be, it's the preponderance of the evidence. Criminal is beyond a reasonable doubt. The burden is always on the prosecution. Whereas when you file a lawsuit in civil court, the burden is on the plaintiff. Now, FOIA is a little different. FOIA, I file the suit, but the burden shifts. The burden is now on the government to prove that they meet the requirements under FOIA to deny it. And what the federal government has to do at that point is go through what's called the Vaughn analysis. And off the top of my head, I don't know the elements of the analysis, but what I can tell you is they basically have to meet a threshold level of evidence to prove to the judge that they're properly denying under whatever provision they're relying on. So in this instance, the provision they relied on was 7A, so they would have to prove to the judge that they met those requirements. Now, the unique thing about this is, my understanding is, the Vaughn analysis is done in camera, which we know is in front of a judge privately. So if I did file a lawsuit and they go through the Vaughn analysis, I don't think I would be privy to what they present to the judge. Now, that's just my basic understanding. Without doing any real research, that was what I kind of concluded. So I don't know what I'm going to do yet. I don't know. So I could go into federal court. I could say, you know what, this just isn't worth it, and end it there. I don't know. Okay. I got plenty of time. Just need to stew on it.
Very well. I should have said, by the way, this is, don't rely upon anything that we say here. Not intended as legal and financial advice. Two crackpots talking about nonsense. Really.
No.
And we thank you, by the way, we thank you for all you out there who are here tonight and in the past. So thank you.
Yeah, we were described in the comments as knuckleheads, which I'm totally fine with. Because
that's fine. I think that's a compliment. I'll take that as a compliment.
I do too. I think it's a great compliment.
Yeah. So that's the FOIA part. What I wanted to talk about briefly. Did you have anything else you wanted to add about the FOIA part?
No. You said my story was too long, so I'm done.
No, I thought you did a good job of extending it beyond even when I said it was too long. So congratulations, well done, well done, well done. And again, your Eagles won. Your Eagles won,
right.
So you're in good spirits. But just off the side, I spoke to JR yesterday at a time his Eagles were down in Washington, and he was not particularly pleased at that moment. So I wanted to briefly bring you up to date as to my arbitration. As it turns out, today I got my date for my second.
That's good. That's good enough. You're good. That's too long.
I got my date for my second initial conference hearing.
Okay.
I don't know how you have two initial conference hearings, but so be it. And that's November 21 at 2 p.m. So go ahead, do it.
It's like that George Carlin joke where it's time to board the plane. So what do?
That's right.
You get on before you get on.
That's right. You have to board first. That's right. Yes, I don't know. You have two initial conferences, but we do. And just quick. That's MMtlp. I sued Fidelity, and I know a lot of people are having issues now with GTII and MMtlp with Fidelity. We have chosen 3 arbiters who I've objected to all of them in the process, and we have a bunch of motions pending, most of discovery motions, kind of like what JR was talking about, a bunch of requests for documents and share counts and names and addresses and identities and fingerprints. I'm exaggerating a little bit, but a bunch of requests. I think there's like 7 or 8 motions pending that we
I was probably say. Let's take a step back. How many like independent motions? How many things have you filed now? I'm just curious.
In the arbitration?
In total, yes.
Oh,
in total arbitration.
Oh, in the total arbitration, I probably have like between 20 and 25 filings, I would say.
What's the average page length?
They're different. So I would say some are short because I try to keep them as short as I can for my own benefit. No 77-page briefs like Fngr just filed in GTII. How's that? But it's a bunch of stuff. It's a bunch of stuff, and then the other side files a bunch of stuff, and unfortunately, I got to look at what the other side files too, and then Fngr pretends to file stuff, and I got to look at that too, and then I got to bitch to JR about looking at it. So it's a whole deal, but it's going forward, and I'm not unhappy that it's dragged a little bit because other events have happened in the meantime that I can kind of use. So that part is good. But yeah, it's a pain in the butt. It's a lot of work when added to the originals. It's a lot of pleadings, but that's kind of the way it is. That's life in the big city. But I'm hoping we get some discovery out of it. That's the bottom line. If I can get share discovery and because the whole idea was first person that can get something, it works for the benefit of everybody. So I don't really care how it comes out. I'm doing my section, JR's doing his section, and however it comes out, it's great. Whatever. And I think it's more of a collective effort than an individual effort anyway. I think it's everybody pushing as opposed to one person. So, but as to me, that's where I am with the Fidelity arbitration, and the date came today. So 11/21 is today's date. Of course, I will keep everybody updated, and if I could bring a camera in with me, maybe I'll sneak a camera in. I'll bring a. You're not supposed to, right? Because it's supposed to be confidential. I wonder what the remedy would be. What could Fngr do to me if I just showed the arbitration proceedings to the entire community? What could they do? I wonder. I'm not really planning. I'm not planning on doing that. By the way,
I don't know if that's. Yeah, I know you're not planning on. He's totally joking. So I don't know.
I'm not totally joking. I'm 85%
Well,
joking,
they
15%
got
not
a
joking.
terrible argument there because they really can't hold you in contempt, right? Because I mean, we know there's an argument right now to determine whether or not these people are even constitutional. Well, no,
Yeah,
that's the enforcement.
I'm going to certainly go back and analyze the rules as to confidentiality and what the remedies are. Because listen, if nothing else, like trial, that might be interesting for people to watch so they could take a look at what's going on.
You
You know,
might want to research the federal arbitration statute as well too to make sure there's nothing in there you're not aware of.
oh, I'm going to be very careful. Although, you know, my inclination is just to go blind all in and just let the chips fall whatever, you know, whatever. I'm sure JR will bail me out of jail or whatever it's going to happen. But I wonder, I bet, you know, I'm wondering if anybody's ever tried that. Has anybody had the, you know, has anybody ever exposed them like that? I don't know. Anyway, something that occurred to me as we were talking, I hadn't thought about it before, but again, you know, depends on what the remedy is. It might hurt my case, you know. If they found out it was on national TV, it might be a problem about the outcome of my case. Although I don't know if they could use that to decide that. But anyway, it's just a thought that occurred, and I'll explore it, and it'll be interesting to see. Be interesting to see if I also get some type of communication from FINRA before I do anything. It'd be interesting. So,
Yeah.
but anyway, that's the arbitration and MMTLP. Fngr. I know you didn't watch it today. Did you? That's 4. You're following it, by the way. And the thing I wanted to focus on was the borrow rate. So, you know, I think we did at least one live stream and one video where we talked about share lending and borrow rates, whatever. So the borrow rate is somewhere around 250%. And, you know, we're going on time. It's not like it's a couple days. We're going on months now. It's not been 250% for that whole time. But I'm sure the last month has probably been a killer for the shorts.
Well, sure.
They're paying really out the nose. And so, you know, I was wondering if you're in that situation for a prolonged period, how is it possible that the shorts could continue to pay 250% interest? And maybe it is, by the way. I'm not saying it's not, but if it is, then something different is going on. Because what I mean by that, is it possible that there's some alliances that exist, and so there's somebody assisting Alpine, for example, you know, or assisting somebody in paying that interest. Yeah, paying that interest.
Yeah. Well, you don't know, but you can look at it and do the math, and the math was okay. It peaked at what, 725. If they shorted it at 725, they shorted it down to $4. The borrow rate has been at about 200% since $4, and now what did it close at today? 6 and some change.
608.
So what do they got? Another month? What do they got? Another month, and they're underwater. Their trade is upside down, right?
Yeah. Because I think the borrower rate indirectly reflects the number of people that are selling shares, because that reflects the amount of shares that are available. And if people were selling all kinds of shares, then there would be a lower borrower rate. So it sounds like to me that people aren't, and again, I don't know, this is my supposition, but it appears to me that people aren't selling shares. That's why the borrower rate goes up, and it's costing them money unless somebody's fronting it for them. Could Jeffries be fronting money for somebody else? Maybe. But at some point in time, somebody is paying a lot of dough. And at some point in time, somebody who's paying for somebody else would want out too. So
exactly.
And you know, at $6, and if they're at 250, if it goes above $6, it's likely that the number would go higher. And it was interesting. There was a proposal or suggestion. I don't know how serious it was, but in Fngr Motion, I don't know if you saw this, by the way, JR, but in Fngr Motion, somebody suggested Univest is let's say the sales agent for an offering. And people think that they've been involved with other securities where when they had involvement, that security happened to do very well. So somebody was
Right.
suggesting that maybe Fngr Motion, and Fngr Motion can do right now a $25 million offering. Theoretically, it could be up to 300 million with a little additional paperwork. But somebody was suggesting that maybe they bought like 3 million shares and they lent them out to the shorts, and they're going to recall them all. And
Yes.
when they recall them, there will be a price activity, let's say, because there would be that everybody would have to cover. The cost would be large. It would be 3 million shares, which would be a significant amount, and it would be a pretty dramatic impact. You're shaking your head. Do you have any thing to add?
No, I remember seeing that. I think it was last week. Someone had, excuse me, someone had posted that what, not what if, but it's possible that Univest could have purchased a large amount of shares, loaned them out, and is now just kind of sitting and waiting, to call them back.
We don't know.
And then what do they do? Right.
Yeah, we don't know. And all I figure is they want to make money. That's what I would guess.
Right.
I don't think they care what we say. It's a different business, but it's interesting. It's interesting because they've been connected to shorts, and if they took a different approach where they were against shorts, that would change their business model pretty dramatically. So, interesting to see if that was true. I don't know if the person who suggested it was just talking or they had more information. I assume if it occurred, it'll come out at some point.
Well,
in time.
It's a really good thought. You know what I mean? Like it's something that obviously should be discussed. So, which is why we're discussing it.
Yes.
But
now
you don't know. We don't know.
Yeah, like most stuff, we don't know, and maybe after the fact it might come out. Maybe not. I don't know. Maybe Univest wouldn't want to disclose that. That's a tactic they use, and maybe it only be reflected in price action. We never would really know. But it's an interesting. It's an interesting, interesting way of doing business if that's the way they elected to. Now I know that Mark Bazile also filed, or apparently has been able to garner access to the host of the Capybara site. So whatever Capybara's website is on, that host has apparently been contacted, and I think I heard subpoena, but it sounds like maybe they filed an action. They named them, and maybe they'll cooperate and they'll dismiss them from the action. That's my guess. Or maybe it's more informal than that. Maybe there's no action and it just, we're going to do this, and if you do this, we won't do that. Maybe so. It sounds like the host would have no particular interest in protecting Capybara. So
why would they? Why would they?
Yeah, they wouldn't, because it would be to their disadvantage, I would think. But it would. Go ahead.
No. I was just going to say there's no reason for them to protect the whoever has the website.
Now it'll be interesting. We may be able to detect if that was effective. If because we've had two bangs, right? Capybara tried twice to hit the price of Fngr Motion. So if we don't see it again, then I would feel that legal action may have done the trick. Because if one host bails on Capybara, then maybe other hosts won't want to host those kind of sites too.
It's hard to say. What the thing that fascinates me about it all is we're watching this real time. Mark is not shy about what he's doing, which is why obviously we know this. And it's kind of fascinating to see how this is going to play out. It's very cool. And to your point, I don't know what Mark did, but I know he did something. I don't know if he went and got a subpoena from the court, or if he did file an action. I don't know either way, but I know he did something.
Yeah, I don't know if he as far as I know, he's not I don't know where it is. First of all, If it was New
Right.
York, could he file like one of those petitions, pre-filing petitions to identify the defendant? Maybe that would be appropriate. I don't know, because you wouldn't really know unless you filed the petition, because there'd be no way of ascertaining that. So maybe
Right.
that, or maybe it's just that they threaten, I'm speculating, obviously. Maybe they threatened the loss. Maybe they threatened a lawsuit, or maybe it was just a simple call and it was cordial. Maybe it was that. Could be any of those, and all would be appropriate. But ultimately, it sounds like a short would be maybe at risk. And
well, somebody's at risk. Somebody's at risk, whether it's the actual short or if it's an individual that's a middleman that they paid to do this. Somebody's at risk.
Well, also, listen, I would expect that if let's say they identify Joe Blow as the guy who's Capybara and printing that stuff, but Blow is getting his marching orders from Alpine, and I'm just making that up. But then I think Joe Blow might disclose the fact that he was getting his marching orders from Alpine, if that would resolve his situation. So, people generally talk if it's for their benefit, unless they're like, in the mob and they're like ready to go. But other than that, most people will give up. They'll give somebody else up because they value their money or their freedom. Listen, that makes perfect sense to me too. Anyway, it's going to be interesting it'll be interesting to see how Capybara reacts.
I'm giving you up the first opportunity I get.
I appreciate that. I already gave you up. The other thing was the other TD and Benziga who republished that. It'd be interesting to see if they're a little more introspective before publishing things in the future, especially if the action against Capybara results in some litigation and they know that there's a lawsuit, because they're not going to want to risk. And this was what I was going to say is ultimately what stops these people from doing anything. Okay. Threat of jail. That usually is very effective. And then spending a lot of money. So if they have to spend a lot of money in legal fees and they have penalties and those kind of things, that usually gets people's attention.
Agreed.
I had to clear my throat.
He's gonna find them. It's just a matter of time. It might not be as quickly as people think. As you and I know, the legal process is slow. The retail community in general seems to be very impatient when it comes to this stuff. But you and I know that when you go into the court, it takes time. So, but it's only a matter of time. He's going to find them.
Yeah, just in terms of, I was going to mention this earlier, and I'm going to go to one thing after this. But in terms of being slow, it is slow. So, for us, we're kind of used to it. So it seems like it's going at its normal pace. But I know for a normal human being that doesn't deal in that system, it is ridiculously slow. And think about this as slow. I'm going to put this in perspective. As slow as this is, when I first started practicing in 1764, there was a rule in California that you had to have. What happened? What happened?
How could you practice in 1764 and have a rule in California? Now think about that.
It was a pre-state rule. Every state has pre-state rules. So the California had a rule that you had to have the case go to trial within 5 years from when it was filed. Wow. Just imagine that. 5 years. So let's say you were in a car accident or something like that. The insurance company would just hold your money till year 5. And eventually they changed that. So now it's, if I'm filing an action in LA Superior Court, which happens to be the busiest Superior Court in the world, it'll generally take 12 to 18 months to go to trial. And
still a long time.
Still a long time, but that's compared to 5 years. That's like, speedy. And in federal court, kind of generally, I think like a year or less. That's kind of my gauge. So for a normal person, again, that's a ridiculous amount of time. For us, it is kind of like business as usual. But I know it sucks.
Yeah.
I know that, and I can only imagine if I didn't have that, experience, how much discomfort it would cause. So we're there with you. I was going to address something you mentioned it before, burden of proof, and you threw it out. So, just because I think this is a really confusing concept, to be honest. So in a criminal case, it's beyond a reasonable doubt. And they give you a bunch of definitions of what that means, because it could be some doubt, but not other doubt. It's a bunch of nonsense. It's a bunch of nonsense, in my opinion, and it's not really clear. By a preponderance of the evidence which is in a civil case. So most civil cases that go to trial, the standard is preponderance of the evidence. And that's where they give you like this scales of justice. And all you have to do is one side has to go slightly higher than the other side. So that's a much easier standard. And then there's, just to throw it out, there are some occasions where there's another civil standard, clear and convincing evidence, which is more than a preponderance, but not beyond a reasonable doubt. Yeah. So to be honest, I think a lot of those standards are confusing. But you should know for this particular action, if some civil action is going, it's just more, you have to prove more than the other person. And if it's a criminal action, it's got to be basically proof with real certainty. And that's why it's sometimes really frustrating when you don't see prosecutions, but maybe the prosecutor thinks he doesn't have a slam bang case and they don't want to risk the loss. Because the government basically won't prosecute unless they think they're going to win. That's kind of basically their standard. So I find those standards confusing. I hope that didn't confuse you more. But just to let you know that it
didn't really clear anything up.
Yeah, I know. Just want to let you know that I'm as confused as you are, if nothing else. GTII dividend. So if I'm correct, I'm not entitled to.
You're not correct. No, you're not correct.
Okay.
I'm not eligible for the dividend. Sorry, I wanted to tell you that before we started. Yes.
Okay. So neither JR or I are entitled to the GTI dividend, but I'm correct. We both own stock, right?
Yes.
Okay. So we both own GTII shares, and obviously we're interested and we're following it. But I see, or I'm experiencing, or it smells like some people are concerned about being able to obtain their dividends. And I've seen a lot of brokerages referenced, and the concern is, especially after MMtlp, that people are getting kind of vague responses, and they're concerned if there's going to be performance. And I think it's a 10%, so it's 1 out of every 10 is the dividends.
Right.
1 out of every 10 shares.
So if you had 100, you got 10 shares. That's my.
Yeah. Have you heard the same kind of like murmurings?
So I was following this last week closely because there was a post I saw that made me think I want to keep my eye on this. And the recurring theme was that, and I'm going to use Fidelity because that was the one I was paying attention to, but that Fidelity was not going to allow you to trade the dividend shares. And so I don't know what came of it today, but there was an individual that put a post out there that Fidelity basically said, well, they're included in our bulk certificate, and in order to, trade them, you have to call in and talk to the, what X department, and they can sever them from the bulk certificate, but you have to pay like $200 or something like that. Now, I my own personal opinion, that's all bullshit. It's just yet another excuse because they don't have the shares. We heard this during the early days of MMtlp that, well, it was all part of the bulk certificate. You have to pay them in order to get them so that you can transfer them. And what that really is code for, we're discouraging you from calling us to sever them from the bulk certificate. We're going to try to charge you, not a lot, but a reasonable fee, enough to make you think twice about whether or not you're going to do this. And again, they're banking on people not taking action because that's what's always happened in the past. And we've talked about this with MMTLP. They banked on people not taking action. So on some level, call the broker and find out what's going on and find out what they're doing because they owe you those shares. It's that simple. And as Wes said before, they can't make these shares because that makes them an unregistered issuer of the dividend, and that's against the law. So, if you want to know what's going on, pick up the phone and call your broker and find out. And don't take, the first level of customer service, go on to the next level. And if you don't like the answer you get there, go on to the next level. Someone called and asked for the compliance officer and they told them they're not customer facing. So yeah, people need to pick up the phone and call and find out what's going on because each broker, as we know from MMTLP, is handling things different.
Yeah, wouldn't it be great? This is me talking to myself, by the way. Wouldn't it be great if there was one, it'd be great if everybody got their shares. Yay! That would be great.
Right.
If that doesn't happen and we find out that broker dealers are dicking around, then wouldn't it be great if they faced like 10,000 arbitration claims just because if it were me, and JR knows I would do this, but if it were me and they didn't give me my dividend, I'd first threaten to sue them for specific performance. So specific performance is a remedy that you have when you're requiring somebody to perform a certain act arising out of a contract. So here you have an agreement with your broker and they have a duty to provide you the share. And if they don't provide you the share, they haven't performed what their obligation is. So
right.
To me, like the greatest thing is if they could perform and that'd be the end of it. But if they didn't, if they faced some onslaught of claims that completely overwhelmed them because they're lost. It's not like they have a good position. They're just dicking around. They're just kind of, they're just trying to see what they can do, how much time they can get. We don't know what their problems are. We don't know what their specific problems are.
Well, it goes back to what we've said all along in the MMTLP community. It's the same concept. It's the same principle. If nothing is wrong, FINRA and the SEC would have gone to Congress and said, here's the share count. These guys are lunatics.
Yeah.
Right?
I think
if there was nothing wrong with the GTII dividend, you would have had those shares today and they would have been tradable. It's that simple. It's that simple.
Yeah, there's no other excuse. And I think there's a requirement of a legal opinion, but I saw a legal opinion went out too. So
yeah,
I think everything is there. And again, we've seen now, it's hard to believe because now, we're like super in watching this. The lack of kind of sticking to the rules and practices is amazing. Making it up as they go along because they don't think there'll be no remedy for their whatever they do. It really is disgusting.
My question is where the hell is the compliance department in all of this? Isn't someone in the compliance department going, what the hell are you guys doing here? Somebody in the compliance department knows what the share count is for GTII. They know what they have on their books. Books.
Yes. Well, somebody, my speculation is somebody might be telling that person in the compliance department what to do and what not to do. And if they want to retain their job, they have to follow direction.
Yeah, it's disgusting. I mean, it is. It really is.
Yeah, and again, I'll throw it out again. Anybody in the compliance department that wants to become a,
whistleblower.
Yeah, come on down.
Yeah,
because there's got to be people that know.
I actually, and you and I have talked about this. I actually know one of the more prominent whistleblowers attorneys in the country. I was a Cub Scout leader with him, and I actually had no idea that's what he did. until maybe 3 years ago. We were standing out in the church parking lot just BSing, and I knew he was an attorney, but I had no idea what he did. And I said, what do you do? And he actually gave me the Latin term for it. I'm like, what is that? He's like, oh, I'm in whistleblower law. Yeah, good guy, great guy. That's all he did. He's of counsel. He retired. He actually does some stuff with real estate and writes and wrote a couple of different books. But yeah, I can put you in touch with him like that.
Yeah. So it's incredible, and it's obvious. By the way, it's not like that's why we bitch about the SEC and FINRA.
Right.
We know about it's like we talk when we're talking about issues, security law issues. We always talking about it. Then somebody who knows something must be talking about it, because we're just we're issue spotting. We have some familiarity now with it. But if we're seeing this, then the SEC and FINRA are obviously seeing all this stuff. So it's not a matter of not being aware. It's a matter of not wanting to do anything or not being able to do something along those lines. So, if you might, and I'm not suggesting anyone to do anything, but if it were me and they were refusing to give me my dividend, I would not be nice, and I would be strong, and I would keep notes. And if I was able to, I would make sure everything was recorded if it was applicable.
That's right.
I just play hardball from the start. If they're going to dick around, play hard. My view. I know everybody's different.
Let's take a step back. We did a live stream on this where we talked about the importance of taking notes and contemporaneous notes. When you guys are talking to these people, first off, you're going to know right away whether the call is recorded. They're going to tell you right when you call in, the call's being recorded for quality assurances reason. Okay. Take notes. Make sure you write the date, the time, and the person you're talking to. If they won't give you their last name, ask for their customer service ID or their employee ID or whatever their identification number is. They will have one, and write that down too. And make sure not only are you taking notes, but then as soon as you hang the phone up, you go back and you clarify and you rewrite, and then you sign and date and time it the date that the notes were taken. Those are called contemporaneous notes. In most instances, they are admissible.
Yeah, and if nothing else, you could use them to refresh your memory. So
exactly.
If you were testifying in court and somebody asked you about a conversation you had on October 30th and you didn't remember, but you had these notes, you could look at the notes and you could use them to refresh your memory and discuss them. So for a lot of reasons, it's helpful. And at this point in time, we know these guys are scumbags, right? We know all these guys are scumbags. They don't play straight. So you have to be prepared to deal with them, and let's be prepared. So everybody be, as professional as you can in dealing with them. But, I'm upfront when I deal with people like that. I could be courteous, but I'm pretty upfront. There's no excuse. They're just dicking around. And by the way, to Ted asked a question. I don't know. Ted was asking whether his dividend shares were worthless. I think that was his question. Obviously we don't know, but I don't see any reason if they were issued and they have value, why they'd be worthless.
Why would they be worthless?
What Fidelity is electing to do is different. That's a different question. But I don't think it affects the value of the security. But like I said, neither JR or I hold the dividend, although we both hold, just so you know, it's not like we hold minimal positions. We do. We just got into them after, I think it's April 20th or whatever the date was. I think it was April where the dividend was you had to be a shareholder of record.
The record date was April. Right.
So neither of us were owners at that time, unfortunately, but we are now. So we don't have insignificant positions. So we're certainly interested and we're watching carefully, but that one issue or not, but we certainly wouldn't tolerate it. So anything else you wanted to add to the dividend?
No, I'm just watching the questions as they come up. That's why I can't.
Yeah, if you see anything that you're interested in, go on. So I did a video about this, but I wanted to talk about it. The brief. So FINRA filed so let me go back. So this is GTII and Alpine was the broker, and they did a lot of nasty things. So there's a lot of legal proceedings that are going on. And currently, FINRA cannot kick them out. So this appeal kind of has to be decided before we know how we can proceed against Alpine. And there's been a brief filed by Alpine on an appeal, and the appeal is in district court. The appeal is of the denial of the injunction by the district court. So the district court, which is the lower court, denied it. They took it up to an appellate court. The appellate court granted the temporary injunction, but the appeal relates to the denial by the lower court. So that's kind of what is being adjudicated. And there's a bunch of briefs that were filed by Alpine and a bunch of friends of the court. And FINRA finally filed their brief. And their brief basically, and the argument by Alpine is basically that FINRA is basically part of the government, and they should be bound by the constitutional requirements of the government, and that the FINRA shouldn't have their own, the SEC shouldn't have their own judicial system. It really should operate through the federal courts. So FINRA just filed their brief on the appeal, and in the brief, they basically said, we're not a state actor, and therefore, because we're not this is 77 pages, by the way, but my summary is, we're not a state actor, so we're not bound by the Constitution, and this part was also kind of a condition, although it's not. They asserted that they are closely supervised by the SEC, and because of that, they are no harm, no foul. They can operate as they do, and Alpine has no right to an injunction. On top of that, they also claim, and this is I would have made this my number one argument. They also claim.
Hold on. Let's take a step back. So they make the argument in their brief that they're closely supervised by the SEC?
Yes.
Interesting. So then if they're closely supervised by the SEC such that they believe they're not a state actor, then wouldn't it follow that the SEC would have had to have approved the U3 halt for MMtlp?
Well, I don't know, because they use that term without defining it. I don't know that means if that's every.
Well, that's a pretty big deal. That's a pretty big deal. I would think that if you're trying to maintain your SRO status and making the argument that your enforcement officers fall under the preview of the SEC because you're closely monitored by them, then I would say any type of extraordinary event would need to be approved by the SEC in that regard.
Yeah, I would too, except that we're talking about Alpine, not MMtlp.
Yeah, I know,
but in concept, yeah,
it's coming
but
out.
in concept, listen, when I saw that closely supervised, that's the same thing that occurred to me. That means that any material decision, it's got to be run by the SEC, or else they're not closely supervising. And I don't know if that's true. I don't know if it's true factually, or I don't know if they were just throwing it out because from a legal argument, it helped their legal argument. But
it helps their legal argument in that case.
Yeah, in that case. But in my perception, it doesn't appear they're closely supervised. It doesn't. It seems like they kind of run it as they choose. And there's a bunch of cases that are challenging their authority, and basically the position of the parties that are challenging the authority is that they investigate, they prosecute, they penalize, and they expel, that they do everything. And it takes about literally, there's like 9 different steps that as they go through FINRA. And then finally for the SEC to get involved, it's like 19 years later, and it's, the horse is out of the barn. So it's really not supervision, but it caught my attention. That's what caught my attention. The last part, which I thought should have been the first part, was they argued that there's a compelling interest for FINRA to be able to protect the public from Alpine, who's ripping everybody off. That to me, they threw that like an afterthought. I thought
But it's not
that's
compelling
the
enough
lead.
for them to go into federal court and get rid of them.
Yeah, I know. To me, that's the lead, that there's a risk to the public. And then, because I've actually done videos about that, because on the injunction, you have to show there's an element of equity. So you got to show you're in good faith. Alpine are
Right.
scumbags. So I would have led with that, because that's like bearing the lead in this case.
Right. Well, I mean, look, we know the real answer here. We know why they went after Alpine to begin with. It had nothing to do with protecting retail. That was an afterthought. They went after Alpine because Alpine was cheating the DTCC out of their money.
Okay, so I'm bearing the lead here about
actions. Go ahead.
Right. So I buried the lead about Alpine because I think they acted in bad faith and equity, and I've gone through multiple times that between like 1984 and 2022, over 40 times they were disciplined by the SEC and FINRA, et cetera. And apparently they filed 10 lawsuits against FINRA and the SEC, and to this point in time have not prevailed in any of those lawsuits. And they had some guy who was prominently involved in the shorting or dealing with regulators, who apparently was a sex offender, added to the equation. So I'm reading through. So I have that in the back of my mind. So I think I think they're scumbags. They should be out. I think FINRA, obviously, or the SEC should take immediate action. As you said, go into federal court, put these guys out of their misery and protect the public. So I'm reading their brief, and then I see that there's two cases, a federal case and an appellate case. And they were sued by the SEC for violation of the Bank Secrecy Act. Right. So after 9/11, in 2002, there was a law passed, and I think for banks it's $10,000, but I guess for brokerage it's only $5,000. But if there's a transaction that's suspicious, or you should recognize as being suspicious, or you're involved with, or you think might be illegal, you have to prepare something called a suspicious activity report, and you have to submit it to the authorities, the regulators, to review. And between 2011 and 2017, literally, there's thousands of occasions where either they didn't submit a report or their report was not complete, enough to the extent that it was the language that was used in the court cases was that they were trying to obscure the information from the regulators. So what happened was there was a case, SEC sued Alpine, and they got a penalty imposed against Alpine for $12 million in 2017. Yeah. In 2019, it went up to the Court of Appeal, and they lost. Alpine lost. So Alpine either paid $12 million, somebody paid on behalf of $12 million or more. My question is, why hasn't the SEC attempted to collect that $12 million? Because I'm guessing that Alpine hasn't paid that $12 million. That's just my guess. I may be wrong. And because the SEC and FINRA, kind of part of their whatever they throw out, is they're not a collection agency. So it may be they could get a fine, but if the company doesn't voluntarily pay, they may not collect it. And, because all the rigmarole, all the stuff that's going along about Alpine, maybe the SEC hasn't done anything because they had a bunch of legal proceedings, and maybe they figure if we're going to lose, maybe we don't want to press that at this point in time because we'd have to return the money. Go ahead.
I see a FOIA request in here somewhere.
Okay. But $12 million to Alpine? If Alpine paid $12 million, I think that's the end of them.
I don't know. I
mean, I don't think I don't think it's insignificant.
Yeah. No, it's not.
And
that's
because we see fine. It's a big fine, definitely. And again, because I think they thought they operated intentionally and they were trying to not be straight. And, my point is it's an anti-terrorism law. That's what the purpose is. So people can't launder money, transfer money. So,
Right.
we have had enough concerns about these guys. So now we got to be concerned they're funding terrorism or they're laundering money, because that's what you would suspect if somebody was not
Sure.
acting in compliance with the act. Maybe there's
Well,
maybe they're just, yeah, go ahead.
that's why it was enacted in the first place. That's why the law was put in place.
Yeah, and maybe maybe there's an innocent explanation for it. Maybe they didn't do anything wrong, but it's interesting. So they got a fine, and they were ordered not to commit the same violation. But that would have been the very end of 2019, 2020. My guess is nobody's checked after that.
Right.
This is not like the banking regulators checking on. This is the SEC or FINRA checking on these guys.
Right.
So I doubt if they've done anything to check. So what struck me, I wondered why the DOJ hadn't investigated these guys based upon the violations of the Bank Secrecy Act.
Yeah.
I mean, I don't know if it's happened. I don't know if they have, but if they haven't, why not?
Right.
And
yeah,
we also know, and to kind of add to this story, kind of why I throwing this out, we also know they have the Cayman Trading Limited Company, if you recall, where Alpine did all of its foreign trades through the Cayman Islands, never made it back to the United States. We don't, and that by itself smells bad, right? So when you kind of put that together with the suspicious activity reports and the sex offender, the 40 times they've been, sanctioned, they got expelled, at least, it hasn't been enforced, but they got expelled. Yeah. I don't see why there's not more investigation of them, because I think at least maybe there's innocent reasons for whatever has gone on, but I would think our law enforcement should be protecting us, especially now. Listen, right? Current events, come on. Based on current events, isn't that relevant? And
you would think so.
And I know there's a new unit, right? Because there's a new unit we talked about, but I saw recently there's a new unit in the FBI in LA based that is designed to deal with financial crimes. I don't know if they know about this. They should.
Yeah.
It really does, it really does bother me, because these guys, there's nothing that I can think of that they wouldn't do, because the part with the sex offender, if you remember that part where they tried to make him a representative of the company, and they knew it wasn't like they didn't know the story. They fully knew the story.
Well, they argued that it wasn't. They argued that it didn't fit within the FINRA rules and regulations. That was their argument. Remember, they weren't arguing that he wasn't that he didn't do those acts. I mean, the guy pled guilty. They were trying to nestle him into basically the exemption under FINRA's rules.
Yes, I'm going to answer this one quickly. So it depends who's suing. So if it's a claim, I'm reading BH's question. He's asking about compensatory damages assessed against the companies. Why aren't they paid to shareholders? They may be the claims of the company as opposed to the shareholders, because it might be the company that's damaged. It's not that the companies can't pass that on. They might be able to pass it on as a dividend or something like that if there's enough money received. But that's why doesn't go directly to the shareholders. The only way it would go directly. The only way to go directly to shareholder would be if, like, there's an arbitration claim and you have an individual claim, or you have an individual claim against another defendant and you're able to prevail, and and it's your claim.
Well, I think I'm reading this question a little differently. I think he's asking why, when they find these companies for for the violations that we pull up on FINRA's site for marking shorts as longs and and for, naked shorting like Savvy, why aren't the shareholders getting some of that money? And the reality is, when they press charges against Savvy, or, when they ultimately, go do the enforcement action and find him guilty, we never know what companies they're talking about because they don't disclose that information.
Yeah. Yeah. And you're right. So, what they do is they use it for their own purposes, whether that's a nice
Right.
Christmas party, a giant Christmas party. Is that an extra vacation for the head of the SEC? I don't know. I don't know how closely their budget is. I don't know if they need this money to survive. I do not
Right.
know. Because they don't seem to be overly efficient. I can imagine, by the way, that the next round, when they have to ask Congress for money, seeing what MMtlp and all the questioning that's gone on, their next round for financing, where they have to ask the government to fund them, I don't quite think that's going to be an easy task. I think it's not going to be easy. It certainly shouldn't be.
Agreed.
All right. So I don't know if I answered that. I think it should be. Should it go to the shareholders? I think it should be. If the shareholders have been the ones who've been harmed, why not? But the Gary Gensler and Robert Cook, I guess, think that they disagree. They think it should go in their own coffers. And, obviously they have no interest in retail shareholders or protecting them. This is just another sign of that. Because wouldn't that be a sign of good faith? How about like that? Why not decide to allocate a certain percentage of the fines going back to the harmed shareholders, just as a sign of good faith?
The fines aren't enough. I mean, you saw some of those fines on FINRA's website: $8,000 here,
Oh, yeah.
$5,000 there. I mean, quite frankly, they should be fined for the entire amount of profit they made. They should be fined. That's what they should be.
Yeah.
That money should go back to the company. End of
Well,
story.
I would take it even farther. So my system would be they have to return everything they've received. So that's profit and just costs. They have to pay a penalty. They have to pay whatever costs are associated with any proceeding, and they have to pay legal fees. So let's let them do that and see how long this nonsense continues on. Because this is, again, this is not a case where the SEC or FINRA couldn't stop this. Of course they could. If the penalty was sufficient to discourage people, they wouldn't do it. If they were going to go from being profitable to unprofitable, people would stop doing it.
They should make the compliance officer in every one of these corporations at the end of the month sign off that all their trades have settled, all their trades were marked properly, everything was kosher. And when it's not, and when they get dinged, they should haul these guys off to prison for 30 days, or they should be personally liable for the data that they provided to the federal agency. I guarantee you, it's only going to take one time, one compliance officer, and things will change.
Yeah, it's interesting you say that, because I was thinking about that New York case that suggested that the brokerage could be responsible for the activities of its clients. How about like compliance should be personally responsible for the actions of the broker? Yeah. So
you'd either have a lot less compliance officers willing to sign that, or you'd have a lot of broker dealers following the law.
Yeah. But again, this is not a case where it's not possible. These are all remedies that would resolve it. It's just they're not willing to do that, But again, I think the more pressure and the longer this continues, the more difficult it will be for them to at least withstand some. We're not saying that it's going to be like a complete change of everything, and maybe it'll take, quite a period of time. But gradually, I think the rules will change, because the guys will get kicked out. They'll get sued. Just will not become palatable to do. And by the way, just going back to another thing that I should have mentioned, when we're talking about share lending, the solution to share lending is just capping the interest rate. So you can't pay 250%. Usury in California, and you and I have discussed this a little bit. Usury in California is 10%. So you can't, unless you're a broker, you can't pay more than 10%. So do do a 15% max cap, and let's see how much share lending there is with the possible exposure of dealing with naked shorts. Let's see how much share lending it is. Of course, the broker dealers they'll scream to high heavens saying they don't do anything wrong and it's going to cost them, a mint, which it will. But it's also true that they don't care. They don't police it. They don't monitor it. And it's in their interest. If they could lend the same share out 10 times, that's great, because that's a bunch of money in their pocket. So
damn right.
We don't want to.
That's exactly what they're doing.
Yeah. So that one decision in New York, it'll be interesting. And I was going to talk about that a little bit. So there was one decision. We'll see if it's adopted by other courts. But just to kind of be clear, just because one court in a courthouse has a decision does not mean that anybody else has to follow that decision. So,
correct.
Yeah. But it will be cited by guys like me in arbitration, as I've already done. So that's that. I saw an article that was posted about Genesis. There was a short squeeze in 2001 from a company called Genesis. And what was interesting, and I think the analogy was to finger motion, that 90% of the stock was owned by insiders. So either the company owned it or there were just big shareholders that may be MMtlp, just thinking about it too, because MMtlp had really big ownership by certain individuals too. But so there was a short squeeze at Genesis because there was basically two owners of 90% of the shares. And in the end, they said basically the reason why the stock squeezed was because there was limited ownership. There was insider ownership. So I know, like in Fngr Motion, 51% I think is owned by insiders. But outside of that, there's big owners of large blocks of shares. So insiders, in effect, own a lot of shares. And this was an article from 2001. We talk about like short selling and short squeezes are new. Although in the article, it was really funny. This is an article in the LA Times. It put short squeeze in quotation marks. So it had to define what a short squeeze is, like nobody knew what it was. So it was interesting. That was 2001.
Yeah. Now everybody knows it.
Unfortunately, everybody knows about it. Last but not least, I'm going to quickly touch on Tesla. So Tesla is being shorted to the dickens. So last time when I told Elon to jump on board, and I said it was the most heavily shorted stock and probably illegally shorted stock, and it would be for Elon and every shareholder's benefit and for everybody's benefit. If Elon could lead the charge against naked shorting, that would be beneficial to everyone. But since that last time I said it, I think Tesla, which I own, unfortunately, at the current moment, was down to like another 10 to 15%. So reaching out, as I'll do every week, it's to your benefit, to your shareholders' benefit, to my benefit, and to everybody's benefit. If you decided to lead the charge to a cause that you've already said is justified. It's not like you're not on our team. You're on the right team. So we really would welcome your participation, especially now that you're the subject to the same problem.
Right.
I saw a question about Fidelity. I'm going to answer that. That was quickly. No, that wasn't the one. I'm not sure because so the question is by Al Roglin. I'm sorry if I mispronounced your name. Fidelity is quite concerned that they may go bankrupt if they're held responsible for collusion. I am not sure. I'm sure they're concerned about how much they would have to pay. But Fidelity is huge, and we don't know how big they are because it's a private company. But we do know that the CEO of Fidelity might be the richest woman in the United States. And if you go to a lawyer, you might. So if you came to me and you asked me what are my potential damages, so I might tell you you might get $1 trillion, but I'd say the most likely area would be between $20,000 and $50,000. So I might give you a wide range. And when Fidelity is being advised, and I don't know this for a fact, but a pretty good guess. When Fidelity is being advised, they're also being advised of what their exposure range is. And
Right.
even though we might think their exposure range is, way like to Mars, they might think differently, and they're being advised. And they also might have insurance for some of this. So if they have insurance, that might cover part of their legal fees. It also might cover part of liability. We don't know. They also have, we think, that they're a member of the DTCC, so there's a collective there. And if they were stuck and they didn't have enough, they probably could get contributions from others, and the DTC can get contributions. So Fidelity might be concerned, but I don't think they're concerned about going out of business.
Right.
Anything else you wanted to address tonight, JR?
No, it was good conversation. Hope we provided some good content, and yeah, that's all I got.
Yeah, and obviously every week something new pops up, because it does. And I'm sure this week's stuff will come up, and we'll keep you apprised to the extent we can. And obviously I'll keep you apprised of arbitration, and JR will keep you apprised of his FOIA appeal and what he's going to do. And we will be monitoring things closely. Again, if anybody has any questions after this and they want to ask them, we read everything. So if you want to put questions in the comments, we will try to respond. We really appreciate everybody who was here tonight. We appreciate all the questions, and hope everybody has a great week and a financially successful week and a non-stressful week. We wish you well, and thank you for joining us.
And we'll see you next Sunday.
Yes. Yeah, we'll have a Sunday night version of the Sunday night live stream. Anyway,
yes.
Have a great night, guys, and thank you again.
Thanks, everybody.